A Qadi is the magistrate or judge of the Shariʿa court, who also exercised extrajudicial functions, such as mediation, guardianship over orphans and minors, and supervision and auditing of public works. The word Qadi comes from a verb meaning to judge or to decide. History. The term Qadi was in use from the time of Muhammad, and remained the term used for judges throughout Islamic history and the period of the caliphates, while the muftis and fuqaha played the role in elucidation of the principles of jurisprudence and the laws. The Qadi remained the key person ensuring the establishment of justice on the basis of these very laws and rules. Thus, the Qadi was chosen from amongst those who had mastered the sciences of jurisprudence and law. In constructing the legal doctrine, these legal scholars took as the point of departure the precedents already established by the Qadis. During the period of the Abbasid Caliphate, the office of the Qadi al-Qudud was established. Among the most famous of the early Qadi al-Qudud was Qadi Abu Yusuf, who was a disciple of the famous early jurist Abu Hanifa. The office of the Qadi continued to be a very important one in every principality of the caliphates and sultanates of the Muslim empires over the centuries. The rulers appointed Qadis in every region, town and village for judicial and administrative control and to establish peace and justice over the dominions they controlled. The Abbasids created the office of chief Qadi, whose holder acted primarily as advisor to the caliph in the appointment and dismissal of Qadis. Later Islamic states generally retained this office, while granting to its holder the authority to issue appointments and dismissals in his own name. The Mamluk state, which ruled Egypt and Syria from 1250 to 1516 CE, introduced the practice of appointing 4 chief Qadis, one for each of the Sunni legal schools. Although the primary responsibility of a Qadi was a judicial one, he was generally charged with certain non-judicial responsibilities as well, such as the administration of religious endowments, the legitimization of the accession or deposition of a ruler, the execution of wills, the accreditation of witnesses, guardianship over orphans and others in need of protection, and supervision of the enforcement of public morals. Functions. A Qadi is a judge responsible for the application of Islamic positive law. The office originated under the rule of the first Umayyad caliphs, when the provincial governors of the newly created Islamic Empire, unable to adjudicate the many disputes that arose among Muslims living within the territories, began to delegate this function to others. In this early period of Islamic history, no body of Islamic positive law had yet come into existence, and the first Qadis therefore decided cases on the basis of the only guidelines available to them: Arab customary law, the laws of the conquered territories, the general precepts of the Qur'an, and their own sense of equity. During the later Umayyad period, a growing class of Muslim legal scholars, distinct from the Qadis, busied themselves with the task of supplying the needed body of law, and by the time of the accession to power of the Abbasid dynasty in 750, the work could be said to have been essentially completed. In constructing the legal doctrine, these legal scholars took as the point of departure the precedents already established by the Qadis, some of which they rejected as inconsistent with Islamic principles as these were coming to be understood, but most of which they adopted, with or without modification. Thus the first Qadis in effect laid the foundations of Islamic positive law. Once this law had been formed, however, the role of the Qadi underwent a profound change. No longer free to follow the guidelines mentioned above, a Qadi was now expected to adhere solely to the new Islamic law. and this adherence has characterized the office ever since. A Qadi continued, however, to be a delegate of a higher authority, ultimately the caliph, or, after the demise of the caliphate, the supreme ruler in a given territory. This delegate status implies the absence of a separation of powers. Both judicial and executive powers were concentrated in the person of the supreme ruler. On the other hand, a certain degree of autonomy was enjoyed by Qadi in that the law that he applied was not the creation of the supreme ruler or the expression of his will. What a Qadi owed to the supreme ruler was solely the power to apply the law, for which sanctions were necessary that only the supreme ruler as head of the state could guarantee. Qualifications. A Qadi must be an adult. They must be free, a Muslim, sane, unconvicted of slander and educated in Islamic science. The performance must be totally congruent with Shariʿa without using their own interpretation. In a trial in front of a Qadi, it is the plaintiff who is responsible for bringing evidence against the defendant in order to have him or her convicted. There are no appeals to the judgments of a Qadi. The Qadi must exercise their office in a public place, the chief masjid is recommended, or in their own house, where the public should have free access. Qadis must not receive gifts from participants in trials, and they must be careful in engaging themselves in trade. Despite the rules governing the office, Muslim history is full of complaints about Qadis. It has often been a problem that Qadis have been managers of waqf, religious endowments. The qualifications that a Qadi must possess are stated in the law, although the law is not uniform on this subject. The minimal requirement upon which all the jurists agree is that a Qadi possess the same qualifications as a witness in court, that is, that they be free, sane, adult, trustworthy, and a Muslim. Some require that they also possess the qualifications of a jurist, that is, that they be well versed in the law, while others regard those qualifications as simply preferable, implying that a person may effectively discharge the duties of the office without being well versed in the law. This latter position presupposed that a Qadi who is not learned in matters of law would consult those who are before reaching a decision. Indeed, consultation was urged upon the learned Qadi as well, since even the learned are fallible and can profit from the views of others. Those consulted did not, however, have a voice in the final decision-making. The Islamic court was a strictly one-judge court, and the final decision rested upon the shoulders of a single Qadi. Jurisdiction. The jurisdiction of a Qadi was theoretically coextensive with the scope of the law that he applied. That law was fundamentally a law for Muslims, and the internal affairs of the non-Muslim, or dhimmi, communities living within the Islamic State were left under the jurisdictions of those communities. Islamic law governed dhimmis only with respect to the relations to Muslims and to the Islamic State. In actual practice, however, the jurisdiction of a Qadi was hemmed in by what must be regarded as rival jurisdictions, particularly that of the Muslim court and that of the Shariʿa. The Muslim was a court that heard complaints addressed to it by virtually any offended party. Since Islamic law did not provide for any appellate jurisdiction but regarded the decision of a Qadi as final and irrevocable, the Muslim court could function as a kind of court of appeals in cases where parties complained of unfair decisions from Qadis. The Muslim judge was not bound to the rules of Islamic law, nor for that matter was he bound to any body of positive law, but was free to make decisions entirely on the basis of considerations of equity. The Muslim court thus provided a remedy for the inability of a Qadi to take equity freely into account. It also made up for certain shortcomings of Islamic law, for example, the lack of a highly developed law of torts, which was largely due to the preoccupation of the law with breaches of contracts. In addition, it heard complaints against state officials. The Shariʿa, on the other hand, was the state apparatus responsible for criminal justice. It too provided a remedy for a deficiency in the law, namely the incompleteness and procedural rigidity of its criminal code. Although in theory a Qadi exercised a criminal jurisdiction, in practice this jurisdiction was removed from his sphere of competence and turned over entirely to the Shariʿa, which developed its own penalties and procedures. What was left to the Qadi was a jurisdiction concerned mainly with cases having to do with inheritance, personal status, property, and commercial transactions. Even within this jurisdiction, a particular Qadi's jurisdiction could be further restricted to particular cases or types of cases at the behest of the appointing superior. The principle of delegation of judicial powers not only allowed the supreme ruler to delegate these powers to a Qadi, it also allowed Qadis to further delegate them to others, and there was in principle no limit to this chain of delegation. All persons in the chain, except for the supreme ruler or his governor, bore the title Qadi. Although in theory the appointment of a Qadi could be effected by a simple verbal declaration on the part of the appointing superior, normally it was accomplished by means of a written certificate of investiture, which obviated the need for the appointee to appear in the presence of the superior. The appointment was essentially unilateral rather than contractual and did not require acceptance on the part of the appointee in order to be effective. It could be revoked at any time. Jewish use. The Jews living in the Ottoman Empire sometimes used Qadi courts to settle disputes. Under the Ottoman system, Jews throughout the empire retained the formal right to oversee their own courts and apply their own religious law. The motivation for bringing Jewish cases to Qadi courts varied. In 16th century Jerusalem, Jews preserved their own courts and maintained relative autonomy. Rabbi Samuel de Medina and other prominent rabbis repeatedly warned co-religionists that it was forbidden to bring cases to government courts and that doing so undermined Jewish legal authority, which could be superseded only in matters that pertained to taxation, commercial transactions, and contracts. Throughout the century, Jewish litigants and witnesses participated in Muslim court proceedings when it was expedient, or when cited to do so. Jews who wanted to bring cases against Muslims had to do so in Qadi courts, where they found a surprising objectivity. But the different legal status of Jews and Muslims was preserved. Jewish testimony was weighted differently when the testimony was prejudicial to Jews or Muslims. In Sri Lanka, in accordance with Section 12 of the Muslim Marriage and Divorce Act, the Judicial Services Commission may appoint any male Muslim of good character and position and of suitable attainments to be a Qadi. The Qadi does not have a permanent courthouse, thus the word Qadi court is not applicable in the current context. The Qadi can hear the cases anywhere and anytime he wants. Currently most Qadis are laymen. In accordance with Section 15 of the Muslim Marriage and Divorce Act, the Judicial Services Commission may appoint a board of Qadis, consisting of 5 male Muslims resident in Sri Lanka, who are of good character and position and of suitable attainments, to hear appeals from the decisions of the Qadis under this Act. The Board of Qadis does not have a permanent courthouse either. Usually an appeal or a revision takes a minimum of 2 to 3 years in order to arrive for judgment from the Board of Qadis. The Board of Qadis can start the proceedings at whatever time they want and end the proceedings at whatever time they want. The office of the Board of Qadis is situated in Hoofddorp, Colombo 12. Women as Qadis. Although the role of Qadi has traditionally been restricted to men, some women have been appointed as Qadis in recent years. In 2009, 2 women were appointed as Qadis by the Palestinian Authority in the West Bank. In 2010, Malaysia appointed 2 women as Qadis as well. However, it was decided that as women they may only rule over custody, alimony, and common property issues, not over criminal or divorce cases, which usually make up most of a Qadi's work. In Indonesia, there are nearly 100 female Qadis. There is disagreement among Islamic scholars as to whether women are qualified to act as Qadis or not. Local usage. Indian subcontinent. The rulers of Muslim India also used the same institution of the Qadi. The Qadi was given the responsibility for total administrative, judicial and fiscal control over a territory or a town. He would maintain all the civil records as well. He would also retain a small army or force to ensure that his rulings are in force. In most cases, the Qadi would pass on the title and position to his son, descendant, or a very close relative. Over the centuries, this profession became a title within the families, and the power remained within one family in a region. Throughout India and Pakistan, we now find various Qadi families who descended through the famous Qadi ancestors and retained the lands and position. Each family is known by the town or city that their ancestors controlled. Mayotte governorship. On the island of Mayotte, one of the Comoro Islands, the title Qadi was used for Umar, who governed it from the 19th of November 1835 to 1836 after its conquest by and annexation to the Sultanate of Endazuwani, Songhai Empire. In the Songhai Empire, criminal justice was based mainly, if not entirely, on Islamic principles, especially during the rule of Askia Muhammad. The local Qadis were responsible for maintaining order by following Shariʿa law according to the Quran. An additional Qadi was noted as a necessity in order to settle minor disputes between immigrant merchants. Qadis worked at the local level and were positioned in important trading towns, such as Timbuktu and Jenne. The Qadi was appointed by the king and dealt with common law misdemeanors according to Shariʿa law. The Qadi also had the power to grant a pardon or offer refuge. Spanish derivation. Alcalde, one of the current Spanish terms for the mayor of a town or city, is derived from the Arabic al-Qadi, the judge. In Al-Andalus, a single Qadi was appointed to each province, to deal with issues that fell outside of the purview of Shariʿa, to handle municipal administration. Other judicial officers with different titles were appointed by the rulers. The term was later adopted in Portugal, Leon and Castile during the 11th and 12th centuries to refer to the assistant judges, who served under the principal municipal judge, the extra-judicial. Unlike the appointed Andalusian Qadis, the alcaldes were elected by an assembly of the municipality's property owners. Eventually the term came to be applied to a host of positions that combined administrative and judicial functions, such as the alcaldes mayores, the alcaldes del crimen and the alcaldes de barrio. The adoption of this term, like many other Arabic ones, reflects the fact that, at least in the early phases of the Reconquista, Muslim society in the Iberian Peninsula imparted great influence on the Christian one. As Spanish Christians took over an increasing part of the peninsula, they adapted Muslim systems and terminology for their own use. Ottoman Empire. In the Ottoman Empire, Qadis were appointed by the Veli Ulema. With the reform movements, secular courts have replaced Qadis, but they formerly held wide-ranging responsibilities. during Ottoman period, was responsible for the city services. The charged people such as Sabasi, Bochekbasi, Koplak Subasisi, Mimarbasi in police assisted the Qadi, who coordinated all the services. In the Ottoman Empire, a Qadi, the district covered by Qadi, was an administrative subdivision, smaller than a sanjak. Expansion of the use of Qadis. As the empire expanded, so did the legal complexities that were built into the system of administration carried over and were enhanced by the conditions of frontier expansion. In particular, the Islamic Empire adapted legal devices to deal with the existence of large populations of non-Muslims, a persistent feature of empire despite incentives for conversion and in part because of institutional protections for communal legal forums. These aspects of the Islamic legal order would have been quite familiar to travelers from other parts of the world. Indeed, Jewish, Armenian, and Christian traders found institutional continuity across Islamic and Western regions, negotiating for and adopting strategies to enhance this resemblance.